to today's webinar, Commercializing Your IP, which is part of our series, Progressing with IP. My name is Fasiha, and I work in CIPO's Business Services branch in the Intellectual Property Awareness and Education team. Today's objective is to give you an idea of how to turn a new product, a design, or a brand name into profits. Today's presentation should help you start asking yourself the right questions and evaluate how to best commercialize your ideas. Before we begin, you might be wondering what CIPO does. IP rights are territorial and are managed by the IP offices of countries around the world. In Canada, it's us, the Canadian Intellectual Property Office, or CIPO, that is responsible for the administration of most Canadian IP rights. CIPO is part of the Government Department for Innovation, Science and Economic Development Canada. We handle application guidelines, forms, and examination processes used to issue patents, trademarks, and industrial designs. We also work on increasing IP awareness among Canadians. So as I mentioned, we work to raise awareness for the effective use of IP by Canadians. To this end, our IP awareness and education program delivers a wide range of products and services free of charge to help Canadians better understand the importance of protecting and managing their IP assets. We are a team of content writers, presenters, and IP advisors who can assist innovators, creators, and entrepreneurs in understanding IP before engaging in discussions with IP professionals or others where inevitably their IP will become a central point of the conversation. Therefore, we have the resources to explain what IP is, how to identify your IP, how to protect your IP, how to manage your IP effectively, and perhaps most importantly, where to find help. Our tools and resources are available on our website. We also offer fact sheets, detailed guides, online learning modules, and roadmaps to explain the steps required to register for formal IP rights and more. We also organize seminars and webinars, and it's possible to arrange meetings with our IP advisors either online or in person for more tailored discussions to your needs. In today's webinar, we will attempt to answer the following questions. What is IP commercialization? What should be considered before commercializing your IP? What are ways to commercialize my IP? What roles are involved with commercializing IP? And who can you turn to for expertise? Let's start with an overview of what intellectual property actually is. IP is all around us. It's in the clothes that we wear, the coffee that we buy in the morning, the electronic devices that we use every day, and the music that we listen to on the way to work. IP comes from a creation of the mind. It's actually the form that an idea takes when created that can be protected. A few examples of intellectual property include inventions, symbols, logos, pictures, designs, literary and artistic works, and many other representations. IP rights encourage innovation by giving creators the exclusive right to prevent others from stealing or appropriating their inventions. We find that most businesses have some form of IP, whether it's formally protected or not. In business, IP can set one's goods and services apart from others and is called property because just like real property, rights are acquired with ownership. Like when you own a building or land, you can sell it, lease it, and keep others from trespassing into your space. Similarly, with IP, you can sell it, license it, and exclude others from using it. And also like real property, IP is a very valuable business asset. So here on the screen, you see traditional types of IP and the registered rights that are associated with them. Let's start with trademarks. Trademarks refer to signs that distinguish one's products and services from those of others in the marketplace. A trademark can be a word, symbol, design, taste, or even a sound or a scent or a texture, and a few other iterations. It's what consumers often first see and how they navigate the marketplace. It's really all about being distinctive so that consumers can easily identify a trademark with the associated product or service. Trademarks also include geographical indications and certification marks. Now, with patents, it's all about applying them to functionality and providing technical solutions to a given problem. It's the way you can protect new or improved products, machines, processes, and compositions. The invention to be protected has to be new to the world, useful, meaning that it must work, and inventive. There is also copyright, which typically protects music and other artistic creations. Copyright is all about original expression. It's about creations that use some level of judgment and skill and are not just a mere copy of somebody else's work. Then we have industrial designs. These are concerned with the appearance of an object. Industrial designs serve to protect the unique aesthetic appearance of a product and have no connection to the functionality of a product. It's what appeals to the eye, the unique shapes or patterns that we might see on clothing, fashion accessories, technological devices, etc. And lastly, we have plant breeders' rights, which protect varieties and denominations of new plants. However, CIPO doesn't manage the application process for these. Instead, it's the Canadian Food Inspection Agency that takes care of those. So, IP includes valuable information, and it's important to note that there exist other types of IP which also hold valuable information but cannot be formally protected. One such example is that of a trade secret. A trade secret can be any business information that derives its value from its secrecy. It can be a method, a technique, any know-how, research, analysis, data, a customer list, a formula, or even a recipe. It's some sort of competitive edge, but one that cannot be formally protected. Trade secrets can be incredibly valuable. However, they may not be the best choice of intellectual property protection if your competitors can easily reconstruct or reverse engineer your creations. Reverse engineering is when you can recreate a product just by looking at it or seeing how it functions. There are other examples of non-traditional IP as well, like domain names and websites, which are sometimes confused as trademarks but are actually not the same as trademarks. Social media accounts are another good example, as they contain a lot of IP such as trademarks, copyrights, and more. So what is IP commercialization? Commercialization is the process of bringing IP to the market with the objective of future profits and business growth. Today, we'll be discussing the licensing of technology, the establishment of strategic partnerships, and the outright sale of IP rights to other parties, and more ways to make profit with your IP. You can start by asking yourself the following questions. Do I have IP rights? If so, what IP do I have? And what can I turn my ideas into? You might be surprised to find out that you have more IP than you knew, and that you can find IP in practically all businesses. Therefore, odds are that you already probably have IP, whether or not you realize it. So it's a good idea to start by conducting an internal IP audit and identifying the IP that you own. It may seem like a daunting task to sit down and try to identify which asset can be protected as intellectual property, but luckily for you, CIPO has a great tool to help you out. You can use our IP inventory checklist on our website to help you do a bit of an internal audit with your IP assets. Next, it's crucial for you to make sure that you know who owns the IP and that you can prove its ownership. Although you may think that establishing the ownership of IP should be a rather straightforward exercise, you should know that it can actually prove to be quite a challenge if the IP was created as a result of a collaborative process, which is often the case. That's why, if you're entering into a collaborative contract, never assume that you own the IP, and always take the time to ensure that there are IP ownership terms in the contract that clearly indicate who owns the IP. Here are some golden rules to keep in mind regarding IP ownership in work-related circumstances. It's not because you are the IP creator that you can legally own the IP. For example, when an employee creates something, the IP rights are often the property of the employer. Ownership clauses should always be defined in advance in work contracts. If the contracts are not clearly redacted, the IP ownership is determined by local laws. In the absence of a contract, the employee's IP rights could still legally belong to the employer. If you wish to apply for formal protection of your IP, it's extremely important for you to be able to prove your ownership of your IP because remember, you cannot protect what you do not own. If you wish to enter a particular market and realize that you do not own all of the IP that you would require to enter this market, then you may need to license or buy the IP rights from the owners. Again, luckily for you, CIPO offers best practices and guidelines to assist you in defining IP ownership. Of course, these are just guidelines as we cannot offer you any legal advice. And then, of course, we must do an external audit of the market. Is there a market for what I'm going to be offering? Who is my target audience? Who are my competitors? How am I different to what's already in the market? So you must really investigate the business opportunities and assess whether your idea is commercially viable. And in doing this exercise, we recommend that you elaborate on a business plan. The Business Development Bank of Canada has templates freely available on their website, which are a great starting point. to help you get started and to start asking yourself the right questions and taking the right steps. Next, and this is a very important step that will be relevant throughout the entire IP commercialization process, you must assess the monetary value of your IP. So you ask yourself, why is IP valuation important? Your IP assets are a key component of your business's value and will most likely assist you in attracting potential investors and obtaining financing. Also, assessing the value of your IP can help you determine what type of protection to apply for. As well, knowing how to leverage your IP assets can allow you to negotiate a better license deal and set a sales price, or in some cases, calculate damages resulting from an infringement. There are a few different ways to perform evaluation, and the method will depend on how the results will be used. CIPO has resources on our website to help you learn more on IP valuation methods. You should also keep on assessing your intellectual property as time passes to ensure that you protect all new forms of IP, at least the IP rights that are most beneficial to your needs and that fit the best into your business plan. Part of this should be you thinking ahead and considering whether you will be needing anybody else's IP. If so, it would be wise to consider obtaining a license or even purchasing the IP rights. Now, if you think your idea can be protected with a patent, industrial design, or trademark, search for existing IP rights to learn if your creation is unique and novel. Searching and finding relevant IP can be a complex process, so you should consider contacting an IP professional to help you, as the research part of the process is an important one and it is their area of expertise. For example, make sure your trademark doesn't look like something that's already been filed or registered. You can do your due diligence here by looking on the Canadian Trademarks database on the CIPO website. You can also start searching for current and expired patents, as well as pending patent applications to see if you find anything online that resembles your invention. And once again, you can use the Canadian Patents database online on CIPO's website. You should also look for your competitors and partners and see where they have filed for IP protection, as this is usually a good indicator of their key regions. Do a search in the markets of the target countries that you are interested in to avoid conflicts with the IP rights of third parties. And for any type of IP, please be mindful that you'll need to search the national databases of each target country in which you wish to do business. So what are the limitations of these IP searches? Well, when it comes to patents, patent applications filed less than 18 months ago are only available if the applicant specifically asks for them. It is generally agreed that due to the complexity of claims, vocabulary, and different languages, it's practically impossible to find every relevant publication. Most importantly, to be patented, an invention needs to be completely new to the world, meaning that you will need to take your patent search global to ensure that your invention meets this novelty requirement. When it comes to trademarks, in general, business names are not necessarily registered as trademarks. Also, in some countries, like Canada, trademarks do not have to be registered and may be protected under common law, or in Quebec, the Civil Code. Copyright is automatically established when a work is created. Canada and more than 170 other countries have signed the Berne Convention, which deals with the protection of works and the rights of their authors. There is no international copyright registration system or requirement for formal registration. Most countries have a system in place to allow for the formal registration of copyright, but it's usually only searchable by title. The World Intellectual Property Office, or WIPO, has global databases to assist you, but keep in mind that IP research is a beast of its own kind, and that you should really consider contacting an IP professional to assist you in these searches. An important part of protecting your IP will be to seek formal IP rights in Canada and in all those other target countries you're aiming for. An IP professional can help you prepare your application and manage the application process. Also keep in mind that secrecy is very important in order to protect formal protection. In certain countries, if there's been a public disclosure of your invention, they will immediately decline your application. In Canada, we allow for a grace period of 12 months, meaning that you can still apply for a patent up to 12 months after a public disclosure of your invention. So, how can you actually profit off of your IP? Here are some methods. Sales or export. This means to offer products and services directly to customers with minimal help. Then we have licensing and franchising, which means to give others permission to use your IP rights or your business model. Then we have a partnership, which means to strategically collaborate and share IP with other parties to reach common business goals. Then we have something called assignment, which is to sell the IP and transfer the rights from the owner to the buyer in exchange for money. And lastly, we have what is called a spin-off. This is where a parent company establishes a separate company or a child company to bring IP developed by the first company back to the market. Now, let's talk about licensing. A license is used to give others permission to use your IP rights. The person who licenses those rights is called the licensor, and the person who receives the licensed rights is called the licensee. So licensing is a contract that lets a licensee use the rights holder's IP for certain commercial activities in exchange for some form of payment. A license most often involves IP rights that can be registered. This includes trademarks, patents, copyrights, industrial designs, and plant breeder rights. However, it's important to know that it is possible to license IP that is not yet formally registered, such as patent applications, or IP that cannot be formally registered, such as trade secrets. Now let's talk about important questions or limits to keep in mind when dealing with licenses. So the first question I'm proposing is, will the license be exclusive or non-exclusive? So there are three main types of licenses. The first is a non-exclusive license, which grants the licensee the right to use the IP, but the licensor can still use the IP and may license to other parties to use the same IP. To the contrary, an exclusive license refers to a contract in which only the named licensee can exploit the IP rights. Even the licensor is excluded from exploiting the IP rights then. And finally, we have the sole licenses, which are more rare. In this arrangement, the sole licensee is the only party to use the licensed IP aside from the licensor. Now the next question, in what area of products or services will you allow the licensee to use your IP? Will you let them use your IP in all the range of products and services, or only for a given portion? Then you can ask yourself, how will the price or income be dealt with? License fees come in many forms, including upfront payments, recurring annual or monthly fees, royalty-based payments, for example, 4% of your net sales, and more. All of this must be discussed and determined in the license agreement. Next, you may find yourself asking, where will the license apply? A licensing agreement can be jurisdictionally specific. In other words, you may select a specific territory, region, area, or country in which the license will be valid. Some companies elect to negotiate a worldwide license, allowing their licensee more freedom to use the IP in the jurisdiction of their choice, while others will limit the IP to a specific country in order to prevent the licensee from entering into their own markets. And finally, the term of duration of the license agreement must be planned for. Some quick examples of licensing IP include downloading a mobile application, selling someone else's patented technology in a product, or printing logos from your favorite hockey team on a t-shirt. Now, according to you, is the following statement true or false? I can license my idea to someone without owning a patent or another form of IP. The answer here is false. Why? Well, because we can't grant a license for an idea alone. The concept that you want to license must be materialized enough that it can be identified as a form of IP, whether the IP is formal or not. It would be true if we took the word idea out of there and replaced it by creation or product. Please remember that even though your IP does not have to be formally registered to be licensed, formal IP protection makes licensing easier and usually means that you can ask for a better compensation. Now, can you answer the following question? What are characteristics of an exclusive license? And please note that more than one answer may be acceptable here. So, we have two good answers here, and those are A and B. An exclusive license means that only the named licensee can exploit the IP rights, which also means that even the licensor can no longer exploit the IP rights during the term of the license. Now, let's take a deeper look at franchising. Franchising involves a special type of IP licensing arrangement. It's an agreement in which an individual or a group, referred to as the franchisee, is granted a license to use a business owner's also known as a franchisor's, proven business model. And a proven business model means that the business is successful. So they have access to the proven business model plus associated IP, and they are often given training and support in exchange for fees. Here is the perfect franchising success story. McDonald's. Its simple and efficient business model of quick service and delivery of products consistent in quality was a perfect candidate for franchising. With close to 40,000 restaurants in more than 100 countries, the McDonald's business model depends mainly on the sale of McDonald's products by their franchisees. And this comes to an estimated over 60% of their revenues coming from franchised restaurants, which usually lease properties owned by McDonald's and associated IP, especially their trademarks. What IP rights do you think can be licensed in a franchising agreement? Well, any IP rights. Your franchise business may rely on several types of IP, such as trademarks, copyrights, industrial designs, patents, and trade secrets. Trademarks play a significant role in a franchise because a franchisee typically wants to benefit from the goodwill associated with a recognized brand that has already been established. The franchisor must ensure that the trademarks related to their business have not already been registered in the regions where they wish to expand, as once again, IP rights are territorial. Obtaining trademark protection abroad is essential before considering franchise agreements outside of Canada. As we just saw, the franchisee is the individual who purchases the right to sell the franchisor's goods or services using its existing business model and intellectual property, often trademarks. Here are some special considerations when it comes to franchising. It's important to note that the franchisee has obligations towards the franchisor and vice versa. Franchisors have a duty to police their trademarks and monitor its usage by third parties. To maintain a strong brand and minimize the risk of any dilution or misuse of the trademarks, a franchise agreement should include clear guidelines governing the use of the licensed trademarks, including the manner in which they should be used and the goods and services on which the mark may be used. In exchange, the franchisee must maintain the type and quality of goods and services associated with the brand. A franchisor's key objective is often to sustain quality standards throughout its entire franchise system. A franchisee's success equals to the franchisor's success as well. It is because of this particular dynamic that the franchisor will provide training and support to the franchisee to help ensure that success. It's this significant degree of control from one party to the other that distinguishes franchising from other types of licenses. In today's economy, it can be quite challenging for businesses to try and do everything by themselves. Collaborating with other businesses is not only necessary in many cases, but it's also an excellent way to save time and money. Partnering includes any form of collaboration such as forming a partnership, a joint venture, or receiving grants and contributions from another party. Partners contract for the ownership. You should clearly define at the outset of the ownership of existing IP or background IP and of the IP to be created, also known as foreground IP, and the parties' rights with respect to that created IP. An example can be a new business with better technology partnering with another business that has been around for a long time and has an already large clientele. Both of these companies may have good reasons to join their forces and produce higher value products. Company A wants access to Company B's market and their associated IP, and Company B wants Company A's new technology. This can be a very effective way to tap into another company's capabilities and their local presence. But it can also bring about increased complexity because you'll have to accommodate different corporate cultures, and local IP laws and policies may have an impact on IP ownership. For example, in some countries, new IP may be owned by the government if the collaboration is paid for by public funds. It's important to understand who is going to own which IP rights, who is bringing what IP into the partnership, how the new IP will be owned and shared, and for how long. Next, establishing strategic alliances requires having open discussions and disclosing information about each other's IP assets. The key here is to ensure that each party can make informed decisions. Due to the risky nature of disclosing such information, it is critical to know who you are dealing with and understand how to frame the collaboration. This is called performing due diligence on partners. So make sure you ask yourself the following questions. What is the purpose of this collaboration? What are the IP assets needed to form part of this deal? Who will own any new IP created, and how will rights be managed during and after the collaboration? Do the parties at the table actually have the rights to the IP identified? What is the value of the IP that's being transferred in the deal? Where does IP fit in, and how critical is it to the success of the other partner or collaborator's objectives? It would be wise to conduct your own background search of your potential partner to ensure that you really know who you are dealing with, and to ensure that they are in good financial standing, and analyze their overall business plan to get a clearer picture of who they are and whether your business objectives really align. Next, you may have bought and sold an asset that you own, such as a house or a car. In both of these cases, the rights are transferred from the owner to the buyer in exchange for a sum of money. Selling IP or assigning IP works in the same way. The rights to the IP are simply transferred from one party, the assigner, to another, the assignee, in exchange for compensation, which is usually a sum of money. Unlike licensing agreements which grant permission to use IP under certain conditions, assignments usually do not involve any ongoing obligations once the transfer is complete. An assignment can also apply to all or part of a business's IP rights. The parties really have freedom to draft whatever assignment agreement that suits their needs. Any subsequent use of the IP rights by the assigner will have to be considered an infringement of the assignee's IP rights right after the transfer. However, the assignment agreement can contain clauses that will allow the assignee to license the IP after the transfer. Like any legal agreement, it's important to have the assignment details in writing and to make sure that the related IP office's records are updated when the IP rights are transferred. Although it's considered good practice to register your transfer with the relevant IP office, there is nothing in the law that requires that. It's, however, very important to do so for practical reasons. It's recommended that you consult an IP professional for further assistance. Next, a spin-off happens when a parent organization establishes another entity, the spin-off corporation, with the objective of bringing IP to the market. The spin-off corporation takes on the risks associated with commercialization. This is often the case in universities and other research institutions where they license promising technologies to spin-off companies. The companies are generally new, and their goal is to commercialize the IP that they have licensed from the academic organizations. In a context like this, the licensing of IP is generally handled by a technology transfer office, or a TTO, which serves as a liaison between the spin-off and the institution. Since a spin-off company is often based on a license, it's also important to perform a thorough due diligence on a spin-off collaborator to clarify certain aspects such as ownership of IP and limitations, and to manage expectations and risk. Now, who will perform what role when commercializing IP? Creators and inventors. They will need to understand their intellectual property rights and know their possibilities and limitations. IP managers. This would be a group of people, and in smaller companies, the same people may be used to play several roles and will need to do everything related to IP management. This usually means performing due diligence on partners and parties involved, so background checks and research, as well as assessing and applying for new IP rights and monitoring for infringement. And then, of course, we have IP legal counsel. Legal counsel knowledgeable in IP should be contacted to conduct searches for existing IP rights and contract preparation, and also to inform you about any IP situation's legal implications. All of the resources, materials, and tools that I've talked about contain a wealth of useful IP-related content and are available in many different formats such as audio, video, text, and interactive on our website. We are happy to guide you and give you as much information as possible on IP rights, but we cannot, however, provide you with legal advice. Unfortunately, all of the questions that you see on the screen are questions that require a legal opinion. And you might find that you also need legal help in understanding complex IP topics, obtaining legal advice in case of infringement, or seeking an opinion on strategic positioning and searching advanced databases. To that effect, there are groups and associations of IP professionals that you could turn to. To locate a licensed IP agent near you, you can contact the College of Patent and Trademark Agents, or CIPO, which is the newly formed organization responsible for the management of IP agents. We recommend that you only deal with IP agents that are on the CIPO list of registered IP agents, as those are individuals that have actually passed IP-related exams and are regulated and disciplined by the CIPO. Unfortunately, there are individuals out there who will try and pose as IP experts despite not having the required credentials, so it's imperative that you stay diligent and consult the CIPO website to ensure that you know who you are hiring to assist you with your IP rights. As well, the Intellectual Property Institute of Canada, or IPIC, and the Bar Association are two other professional associations where you can find an IP lawyer or an IP professional. Please do not hesitate to contact us if you have any questions or need any help finding any of the resources discussed today on our website. You can reach us via the contact information that you see on the screen. You can also contact for our intellectual property advisors for a more specific and tailored discussion to your needs by scanning this QR code. And for all general inquiries about IP, you can reach out to our customer service center by phone or email, and the toll-free number is as well provided on the screen there. Lastly, I invite you to follow us on social media, and I also recommend exploring the CIPO newsletter titled IP for Business News, where you can find more information about new IP products, seminars, webinars, upcoming events, and more updates to the CIPO website. So this concludes the webinar on the commercialization of IP. I hope you have learned a thing or two and enjoyed this presentation. To learn more about the topics related to IP mentioned here today, I invite you to watch our other videos and register for live webinars on our website. Thank you so much for watching.